I practice general litigation at Farris, Vaughan, Wilson Murphy in Vancouver. I practice all over general litigation, from corporate commercial to private civil disputes to public law. To the extent I focus on public law, administrative law, constitutional law, and Aboriginal law. In my practice, I hope I bring creativity in framing our legal strategy and framing our case before we get to the hearing. As a generalist, I hope that I can bring a variety of perspectives to bear on any given legal problem. And then when we get to a hearing, I try to offer focused and effective advocacy in whatever forum I practice in before many different courts, many different tribunals and boards. And every occasion is a moment to bring forward advocacy skills that I hope become sharpened by practicing in a variety of areas of law and contexts. My mentor was George McIntosh at Farris, who's now on the bench. And he was a very busy advocate in Vancouver, and from him I learned many things, but one of them is that there's real value in being a generalist and in seeking above all to be an advocate without confining yourself too narrowly to any particular area of the law. Being a generalist allows you to learn lessons from many different contexts, many different legal battles, and so it allows for you to develop that creativity and that judgment that you can bring to bear on any given legal problem. In terms of teamwork, I often act on large matters. There have been several cases that go on for months. Two inquiries come to mind. One was about an 8-month hearing in which we were very centrally involved. Another went on for a year. A reference case that I was involved in went on for months. And at those times, you need to act with co-counsel. You need to split up the case. It's very difficult for counsel to be able to commit themselves entirely to a hearing like that over the span of half a year or a full year. And so you need to learn to trust your co-counsel and to earn your co-counsel's trust in turn. And it requires a lot of collaboration and communication. And in those hearings as well, there are many different parties. These are hearings where there might be as many as a dozen different parties with different interests. And you have to learn to strategize and cooperate and collaborate with those parties where you can. And to know where their interests lie and how you can come together and advocate in common cause where that's possible. In terms of pro bono, I involve myself in cases that have important social ramifications, and so those cases allow me to advocate for the causes that I believe in. I act for interveners before the Supreme Court of Canada fairly regularly and before other courts as well. And I'm involved with the BC Civil Liberties Association on their legal advisory group. And in terms of going to the Supreme Court of Canada, an example of such a case is the recent physician-assisted dying case, Carter. That is an issue that I believe is very important for Canadians. It's very important for people suffering with terrible diseases that they have the security of choice, and so being able to intervene in that case and lend my voice to that cause is the sort of thing that I went to law school for.